And some of these people just took free a few days. So it is impractical that a trial is about to commence here now. It's the detriment of these clients you are seeing. These clients are entitled to a speedy and fair trial, which I think the prosecution is just deliberately trying to take out from them. The second issue I have is that from the time the first group of the accused people appeared in court, we are now about 180 days. And Your Honor, all these accused people you are seeing in this dock don't know or have even not heard and have not seen their complainant since the trial commenced in August. Your Honor, my clients are complaining they might be charged without anyone complaining against the offenses they are allegedly committed. Your Honor, under the Magistrates Court Act, Section 119 is clear, and it provides for non-appearance of a complainant at the hearing. Non-appearance of a complainant at the hearing. Your Honor, will allow me to read this in subsection 1, and it says, if in any case which a magistrate's court has jurisdiction to hear and determine, the accused person appears in obedience to the summons served upon him or her at the time and place appointed in the summons for hearing of the case, or is brought before the court under arrest, then if the prosecutor, having had a notice of the time and a place appointed for the hearing of the charge, does not appear, the court shall dismiss the charge unless, for some reason, if it shall think it proper to adjourn the hearing of the case until some other day. Upon such terms, as it thinks it shall think fit, in which event it may, pending such adjourned hearing, either admit the accused to bail or remand the accused to prison or take such security from his or her appearance as the court shall think fit. And Your Honor, the dismissal of such a case like the one here for us under section 1192 does not bar a fresh charge. Your Honor, as I earlier stated, the accused persons and me, their lawyer, has never seen or even heard about the complainant in this matter. And by law, the complainant must attend court at every time such a matter comes up, which he has failed.
Which law is that, Counsel?
Section 119.
Read it again.
Section 119 of the Magistrates Court Act.
Says?
It compels the complainant attend court as and when the matter is brought up. Two, the issue of the other people that are still at large should not be used to deprive these people that were charged in August. And State in his own statements has said he's not sure when they will finish to look for the other people that are still at large, and he's not sure of when investigations will be complete. The purpose of why this mandatory bail was dismissed was to allow prosecution to start the hearing. It's so disappointing that up to now they are telling us.
Cognizant that these accused persons are innocent until proven guilty. I don't want us to treat them as if they are guilty. Because you came to court with an assertion that you have committed an offense. And we are here as judiciary, as court, we are ready to hear what these accused persons did through the various witnesses that you may arrange for. The issue at hand is about my first two people, I think, was Chideo and I think they came, I don't know which time they came in.
In August.
In August. This court stood with the state in terms of what they had alleged, and we allowed that bail be denied because of the different affirmance that you are given in your reply to the bail applications by both the bail application and the mandatory bail. For me to hold someone since August, and I have not yet heard of anything that is against him or her, I think would be unfair. If you have a case against this person, present it so that we can hear it. And the additions of persons, I think also must come to an end. I think that the state has powers to start a new fresh matter. You have powers to bring as many charge sheets as you can. But for each case is seen as the one that we look at each case on its own facts. I'm not going to rely on others, I'm relying on this case. If I've had someone from August to January, I surely should be seeing someone presented instead of additions which are affecting A1 and A2 and A8. So let us have it proper that more amendments should come on a new charge sheet. You can still charge those other people at large because we don't know if they get them in 2028. So you cannot stand on that because we are hoping someone is going to be arrested. These ones should. They cannot live on that hope. You say they did this individually, bring it against them so that they face the law. Because they are here, every day they come, they are ready to face whatever is against them. I've not seen them not appear. They are appearing because even those that were not able to be brought are appearing. So let us be clear. Because I do not know at what length you're going to still look for those at large. It may even be in 2040. So would we say that these people should stay here? No. I think that is unfair and should be corrected. Any further additions should be having a new fresh charge sheet so that these people can be handled the way they should be handled and a fair hearing should be presented for them at least. Because we have denied bail, we have denied mandatory bail. So surely they are here, prosecute them. So that we hear the case against them. Then the next issue was on dismissal. I cannot dismiss at this moment, reasons being that the more amendments that I've won, I think I've addressed it in the issue 1. State proceed to let us end at M20 and we have a fresh charge sheet because I can't have A1 waiting for A20.
Your Worship,
Even if you say this event happened on the same day, if you say if you are the state, you should be able to get this. Isn't that so?
That's a good idea.
Eh? They are on the run in Uganda. No, let them be prosecuted and move forward, because you are the state, you can bring in these people so that they can face, but I cannot have A1 wait for 8:30. Yet I've denied him bail, I've denied him mandatory bail. I feel that is unfair to the accused person.
Your Worship, we will take that under advisement. However, the prosecution knows its case-based, Your Honor, with respect.
We are leaders of the public. Now, for leaders of the public to be held in isolation of proceedings because of the state having witnesses that we don't even know. We don't know these witnesses. He has just said that they are about to conclude. And if they are saying the truth, then why do they fear the public? If the public is on their side, I don't see any harm that will come to them unless they want to perform evidence, as they have always done, and they keep us in prison. It cannot be
No. Yeah, we've been here. I'm Kakurutu Musime. Today I'm the only lawyer who appeared for the accused persons in court. I appeared late, as you know, because we are having a lot of charges and all lawyers are splitting everywhere. We came here in court, and one of the issues we found today is that they again amended the charge sheet and they have now 20 people on the file, which we raised before the magistrate. We said it is unfortunate and it is against our right, our client's right and personal liberty. So the magistrate has ordered that the state should close this charge sheet and not amend the charge sheet again. That if it has other people, it feels it wants charge, it should make fresh charge sheets and we commence with the hearing. Because we stated clearly in court that the more they keep on amending is the more they delay the trial. And our people, our clients are just suffering in prison. Then the second issue we had was about the complainants. Because me myself as their lawyer and the accused people themselves don't know whether actually there's someone complaining against them. Because we have never seen any and we have not had any. It is so unfortunate, but the magistrate has decided that we can wait for the other date. Then the prosecution raised an issue against you, the media people. He wants you to be chased from covering this case specifically. Why? He said they are threatened. I don't know which threats, and they are the state who have the whole security. As you see, the whole courtroom is packed with soldiers more than us, the civilians. Outside, as you enter, there are members. So which threat are they all to? In fact, it would be me that would be on a threat because I don't have even a small weapon like a pen to use to kill someone. So if a state says he's threatened, to find that one unreasonable and unjustifiable and against your rights as media people to practice freely in Uganda. We have sought for a short adjournment so that we can make our reply, the application that wants to stop you media people from covering this. The unfortunate part is most of the people who are accused and charged here are leaders in the National Unity Platform. They have a lot of following. So by merely restricting or prohibiting media covering this, it will be denying the rest of the people, the public, who believe in these people as their leaders, to know what is happening in court, which is even against the human rights. And as a human rights lawyer, I believe we can have something over that.